Thank you. All right. Hello, everybody. I apologize for our technical difficulties. I'm Samantha with the Law Offices of Samantha Wolfe. We're located at 20 East 6th Street in Suite 206 in Waynesboro, and you can reach us at 717-655-2676. And we always offer initial consultations, and we do that as part of our mission statement. We want to make sure that we're providing assistance and education to the community so that they can have the best legal and estate plan. So this is just a sample of what our mission statement says. And so we always put this as part of our presentation. We want to make sure we're collaborating with accountants and financial advisors so that you have the best team. We want to make sure we're advocating for you and your family in times of crisis. We want to reinforce your estate plan with asset protection strategies, and we want to make sure that we're ensuring efficient administration upon your death. And so we do that here at our office. That's what we're always striving to do. So with that in mind, we're going to start our presentation today. So today we're talking about common mistakes in estate planning. So as I have met with clients throughout the years, just things that I notice that maybe they don't understand, or maybe they could have been explained a little bit better by their legal professional. So we're going to go through some of that. So I'll outline all of these mistakes. I think there are about 6 that I've tried to target today. So we'll go through those 6. And then, like I said, at the end, I'm happy to answer any questions. So thank you so much for being here today. So let's get started. So the mistake number 1 is not having a will. So I know that that seems silly, but you wouldn't realize how many people, especially husbands and wives, who feel like they don't need to have a will because by law everything goes to their spouse. And the reality is, in Pennsylvania, if there's no will, Pennsylvania imposes a set of rules on individuals. So it's what we call intestate law. That's when someone does not have a will. So intestate law is what Pennsylvania has determined is the best way for your estate to be administered. Now, the downside of intestate rules is that a lot of times it doesn't actually distribute your estate the way you would want it to be distributed. So the first thing to know is that if you are the first spouse to die and you have a surviving spouse, it doesn't necessarily go 100% to the spouse, because if you have surviving issue, that means children, or if you have a surviving parent, then what happens is the surviving spouse gets the first 30,000 plus 1/2 of the intestate estate. So we have so many couples who come in and say, well, I want everything to go to my spouse. But if they don't have a will, the reality is Pennsylvania will impose an estate plan for them that is going to deviate from what they want. So it could be that your spouse is only going to get the 30,000 and then half of the estate. The other half will go either to children or to a parent. If you don't have a spouse and you have children, then it'll go 100% to your children. If you have no issue, then it goes to your parents. And if you have no parents, then it does go to your siblings. So it's going to be a different situation when we have husband and wife and we're planning for husband and wife versus if we have a single individual and we're trying to figure out how to divide their estate plan. All that to know that, again, if you don't have a will, this is the estate plan Pennsylvania feels that you would want. So if you don't like this, if you want to make sure your spouse does receive 100%, then you need to make sure that your will specifies that. So what happens? I have some examples here. So let's say that John and Jane and Joe are married with one child. Jane dies and she didn't have a will. So what that means is John's going to get 30,000 plus 1/2 of the estate, and then the children are going to get the other half of the estate. So if she'd had a will, maybe she would have directed everything to John, but because she did not, this is how Pennsylvania will force the estate to be divided. If John and Jane Doe are married and Jane was married previously and had one child with her first husband and she doesn't have a will, then John, her husband, gets 1/2 of the estate and the child gets the other half. So it depends on if you have a spouse, if you have children from a previous marriage, and that will then depend how Pennsylvania divides your assets. So I always like to use this example because so many people don't realize what Pennsylvania law's default is. And so it's always good to know what you're going to be stuck with if you don't do a will. So how do you protect against an intestate estate? That means when you don't have a will. So the first one would be to have a will. The second would be to have joint ownership of assets. So for example, If husband and wife have their primary residence and it's in both spouses' names and one spouse dies, it automatically goes to the surviving spouse. It's not going through the intestate succession, it's not going through the will at all. Same thing with beneficiary designations, and same thing with transfer on death and pay on death designations. So, transfer on death and pay on death, it's not really a big distinction between those two. It's just the institution may call it a transfer on death or a pay on death designation. And you can usually do that on certain types of investment accounts that you might have. So beneficiary designations you're going to see on life insurance and on retirement accounts. The POD and the transfer on death, TOD, are going to be more for investment accounts and stocks. And the one thing I always like to mention here, because we're having a situation that Tammy and I are administering right now, where we're dividing assets at someone's death, we're paying it out, and there's going to be inheritance tax that's going to come in. So inheritance tax is just a tax on someone's right to receive assets when somebody dies. So for example, something happens to my parents and they leave everything to me, I'm going to pay an inheritance tax based on my relationship to my parents. So I'll pay 4.5% on whatever the date of death value is. So when you're trying to figure out taxes and how that tax is going to be paid, you always want to make sure that your attorney is talking to you about, is it going to come out of the residue of the will, or is the tax going to be allocated to the assets that are paying to that beneficiary? So for example, let's say that mom and dad, for whatever reason, wanted their real estate to come to me, but they wanted their retirement accounts to go to my sister. She's actually on the call, so they'd want it to go to Jesse. So what they could do is they could say, okay, well, we're going to have the real estate's going to pass through the will to Sam. The beneficiaries are going to be updated to designate Jesse as the beneficiary. But the reality is that my parents probably, as long as the attorney didn't talk about it and specify it in the document, my parents are probably going to use a general tax allocation clause, which means that the will is going to say any taxes that are due are going to come out of the residue. And if I'm receiving the property in the will and out of the residue, then technically I would be paying the inheritance tax on even the assets that Jess is receiving through a beneficiary designation. So not only is it important to have your beneficiary designations the way you want them, but it's also important that your legal professional, your attorney, is talking to you about where does the tax get paid from. Is it paying through the will, and is that okay because the will is going to have the same beneficiary designations as your beneficiaries? Or is it going to be where it's going to go through the will, it's going to pay out of the residue, and you understand that that's going to be a different beneficiary than that is on the designation forms for the other asset? So just talking through that tax allocation clause is really important. We see it especially impactful when you have individuals that are at different tax rates. So this wouldn't necessarily apply to my parents, but for example, if I passed away, let's say I left everything to my sister and my nieces. So in Pennsylvania, a sibling pays tax at 12%, but nieces and nephews pay at 15%. So if I have designated my nieces as the retirement beneficiaries, but I've named my sister under my will, but I have the will clause in there saying that all the taxes are paid, then again, my sister, before she receives what she's going to get, is going to pay the tax on my niece's share of the assets that are passing outside the will. And so that can make a huge difference when we're talking about taxes and the payment of taxes. The other way to do it is to say that the tax is allocated to the specific beneficiary. And then what that means is that their share, what they're receiving, is just reduced by the amount of taxes. So it does make a difference. And I wanted to make sure to bring that up here because Tammy and I are seeing it more and more when people pass away and we're administering estates. So the first mistake that we're talking about here is all about not having a will and what are the ramifications of that. And what are the ways that you can make sure that you don't end up with an intestate estate? And that's by having a will, having joint ownership, beneficiary designations, and transfer on death or pay on death designations. Mistake number 2 would be dealing with underage beneficiaries. So I would say about 30% of the clients that we meet with have children that are under the age of 18. So the first thing that we do when they come in the door is before we even start talking about a will, we give them what's called a standby guardianship form. What a standby guardianship form is, it's something that Pennsylvania is right in their statute it's a form that you can print off and keep so that if you're traveling, so for example, my sister has two younger girls. So if she would be traveling, and let's say my nieces are staying with me, of course they'd be staying with me because I'm the best aunt ever. So they're going to stay at my house. And my sister is saying, if anything would happen where you have to take them to the emergency room and get treatment for them, we want to be able to give you that ability since we're traveling. So my sister and her husband would actually do a standby guardianship form that would say during this period of time, and it could be, a weekend or a week, however long they're going to be gone, the form would say from this time to this time, we're going to grant this individual, in this situation it would be me, we're going to grant Samantha the ability to be the guardianship for our children during this specified time. Now, once that time expires, I'm no longer the guardian, okay? And this is helpful because you may have underage kids, or your children may have underage kids that stay with you for a weekend, and they may not know that they need to have this guardianship form so that you can take these children to the emergency room and get treatment. And this can be different than the permanent guardian that you may name in your will, which is what we're going to talk about next. When you have minor beneficiaries, you need to have a will because the will needs to say who would physically be in charge of that child's well-being. So because a lot of times we have husband and wife, if they're traveling together, something happens, we want to make sure that we're covered. So it would say, at the death of the second of us, if we still have underage beneficiaries, this is who the guardian would be. And that would be permanently who's the guardian. So again, that's different than the standby guardianship forms, because if it's something where the kids are just staying for that specified time, but maybe that individual is not the guardian listed under the will, again, it just gives them the authority for that specified time. Then if something would happen, then the guardian under the will would take over after that time frame. So that's why standby guardianship forms work in conjunction with the guardianship provisions in your will. Then we also do custodial clauses in the will, and the custodial clause would be who handles the money. So the guardian is who physically is in charge of the well-being of the child. The custodian is who's in charge of the money. So in some families, that may be the same individual. It may be different individuals. I do have one sister that's not really great with money, so I could see where if my sister was naming a guardian, where she might have name my one sister as the guardian, but she may name, for example, me as the custodian. So it doesn't have to be the same person, and you might not want it to be the same person because you might want there to be checks and balances to make sure the kids are getting everything that they need and being properly cared for, but it can be the same person. The other thing to know is that you can name multiple guardians. So for example, if my sister wanted to name my parents, she could name both my mom and my dad as the guardian of the kids. For a custodian, you have to, by Pennsylvania law, only name one person at a time. So in that case, it still may be my mom and dad, but my sister would actually have to say my dad first. And if he can't serve, then it's my mom. And that's just something that Pennsylvania law says, that you can only have one guardian named at a time. So before we move on to mistake number 3, mistake number 1 was all about having a will and avoiding the intestate succession. Mistake number 2 was dealing with underage beneficiaries and just knowing how to deal with that. Mistake number 3 would be not reviewing beneficiary designations. So you have a whole bunch of assets that probably are distributed with beneficiary designations, and a will is not going to distribute those assets. So there are designations where you would name a primary beneficiary, and what that means is then upon your death, that money that's owned in that account, whether it be a retirement account or a life insurance account, or if it's a transfer on death or a pay on death account, it's going to pay directly to the beneficiary. It does not have to go through the probate process. So probate is when the will assets are being distributed according to the will. So probate is just the process by which we name the executor, allow them to then have the authority, and the executor can then follow the will and distribute the assets according to the will. So that's the probate process. But if you have a beneficiary designation, you avoid all of that, because when you pass away, it pays directly to the beneficiary that's been designated on the account. So that's why beneficiary designations are so important. And here at our office, we typically name not only a primary beneficiary, but a contingent beneficiary. I'm going to talk about this a little bit more in some of our later slides, but we do that for a couple of reasons. The first is that way, if that person predeceases you, you don't have to worry about updating the beneficiary designation. But secondly, and probably more important than that, is that we can do some post-mortem planning. So if we have somebody who is doing long-term care protection, which is just an area of law where you try to protect assets against nursing home costs so that your spouse, if one of you would need long-term care, isn't financially compromised while trying to pay for your nursing home. So we do a whole bunch of long-term care planning in our office to help couples protect those assets. And what we might do is we may do a trust to help protect assets, and we may designate the trust as the primary beneficiary. But we may then name a contingent beneficiary. And sometimes I get questions from financial advisors about, well, when you're naming a trust as the primary, why do you name a contingent beneficiary? Because a trust never dies. So it seems counterintuitive to name a contingent beneficiary, but we actually use it as a planning technique. So if I'm going to use my parents again, let's say my dad is in a nursing home and my mom passes away. Well, her retirement was not available for my dad's care. But when she dies, if it's paying to my dad and he's in a facility, then it does become available for his care. And so what we might do is we may say, let's name a trust as the primary beneficiary of mom's retirement so that if when mom dies, if dad is in a nursing home, then it's an additional resource there for him, meaning it's not jeopardizing any benefits he's receiving, but it's there to help supplement anything else that he would need. If dad's not in in this case, if dad's not in a nursing home at my mom's death, then he is going to be named the contingent beneficiary. So he would be able to, as the trustee of the trust, exercise a disclaimer, which means he may say, let's not have it pay into the trust. Let's have it pay to the contingent beneficiary, and he would be the contingent beneficiary. So what this allows us to do is not knowing what order spouses will pass away in and not knowing what health situation you'll be in at the time of your spouse's death. It allows us to plan to protect assets if we would need to do that. And in the event where we don't need to do it, it still allows a great way to get it to the surviving spouse so that you can maximize your income tax planning that way. So it gives us more options. So again, I know some financial advisors have asked that, and so that's why we call it stacking or layering or tiering our beneficiaries. It just gives us more options for when someone passes away. The other thing that we sometimes do is we will actually name like a second contingent beneficiary or a tertiary beneficiary, and we do that because for tax reasons, it might be that the spouse wants to disclaim as the trustee and then disclaim as an individual because they do want the funds to go to the kids. And again, it's just a way to ensure that when someone passes away, you have the maximum planning opportunity to be able to do that. So that's why it's so important to review your beneficiary designations annually. That's what we recommend. And to make sure that the attorney that you're working with and the financial advisor you're working with are working as a team. And there's a discussion about who should be named as beneficiary, what's the best way to do that, so that you have an overall comprehensive plan to ensure that you're achieving your goals, minimizing taxes, and maximizing the protection that you would have. Another way to avoid probate, so this is what we had talked about, would be assigning beneficiary designations. So what's important to know, because there's probate, and that's just the process by which assets are distributed under the will. So there's that, but then there's also inheritance taxes. So I always like to mention here that you may be able to avoid probate by designating beneficiaries, but it doesn't mean that you're going to avoid Pennsylvania inheritance tax. So in the example of my parents, if they had named my sisters and I as the beneficiary of the retirement, we don't have to probate in order to have access to those funds, but we still are going to have to pay inheritance tax at a rate of 4.5% on that retirement. But the designating beneficiaries is a great way to avoid probate. And we like to do that for a couple of different reasons. So again, it's always good to avoid probate. It's good to avoid probate for a couple of reasons. The first is that probate, assets that go through your probate estate, meaning any asset that is distributed through your will, is going to be subject to any creditors at your death. So for example, credit card debt that you might have, nursing home costs that you might have incurred, anything debt-wise, the creditors can collect against what passes through your probate estate. They cannot, however, collect against what passes through beneficiary designation. So a lot of times we will want to work with the advisor to make sure that the designated beneficiary is not your estate, because you can say the estate of and then your name, and that just means it's going to pay according to your will. We don't recommend that in most cases, because if we have a designated beneficiary, then we do avoid those creditors. So the other reason that we like to update beneficiary designations, and I don't know if it's something that attorneys like to talk about a whole lot, but if we have to go through probate, typically an attorney can charge a larger fee than they could if it didn't go through probate. So again, avoiding probate is helpful for a lot of different reasons. And that's one reason why our office typically recommends beneficiary designations. It doesn't mean that there aren't certain circumstances in which we name the estate, but our office does take a little different approach, because our goal is always to make sure that creditors can attach to the probate estate, but not to those non-probate assets. So the other thing is that there are concerns if you don't update your beneficiary designation. So, for example, husband and wife name each other as the sole beneficiary of their IRA, and husband dies first. Wife never updates her beneficiary designation, and she didn't name a contingent beneficiary. So when she dies, it's going to pay to her estate. And that's going to be problematic, because then any creditors can recover against that IRA. So you want to make sure that you have a primary beneficiary and a contingent beneficiary, and you want to make sure that you are updating those designations based on what's happening in your life. The other thing is that you can make sure to title all assets jointly. So a while ago, a couple years ago, when the federal exemption was a little bit different, there was a lot of recommendations to, if husband and wife, to split everything so that everything wasn't in joint names. Now, because the federal exemption is 11.7 million, we're recommending that most assets between husband and wife be jointly titled so that it does avoid probate. Keeping those beneficiary designations updated, so having assets such as an IRA or an annuity pay to the estate instead of to an individual, creates larger income tax consequences, and it does require the estate to be probated. So that's why we recommend an annual review, just to make sure. And that's why when we're doing our estate planning, why we may ask you to list your assets even when we're just doing your basic estate planning, because the designations are part of your estate plan, because it can cause assets to go directly to that beneficiary. There are many things that can happen. So there might be births, there might be deaths, divorces, new property acquisitions. So when you're naming individuals like grandchildren, and maybe you have a new grandchild, you want to add them on as a beneficiary designation. So that's why we always recommend that you have an annual review, just so you can ensure that those designations are in fact what you want them to be, and that it's working with your will. It's also important to consider, if you are charitably minded and you want a certain amount to go to charity, updating beneficiary designations for retirement is a great way to fulfill those charitable wants or desires, because retirement is actually subject to inheritance tax and income tax. So if you can figure out how much of your estate you want to go to retirement, and then you want your estate to go to charity, and then designate that percentage on your retirement, it's going to minimize overall tax, because an asset that was subject to two types of tax will now go to charity and not be subject to tax at all. So that's why it's important to have these discussions with your financial advisor and with your attorney to make sure that you're covering all of these things. And don't be afraid to ask questions about it, because your attorney, your financial advisor, should be able to direct you in the right way. Mistake number 4 is not preparing for incapacity. So I'm dealing with a husband and wife who came in 2 years ago, and we helped do their will. And at the time, I had recommended that they do powers of attorneys, but they had opted to just do the will. They didn't think the powers of attorneys were necessary. So we didn't do any financial power of attorneys, no healthcare power of attorneys. We just did the last will and testament. And we met with this husband and wife earlier this week, and unfortunately, husband was in an accident and is now having some short-term memory issues, as well as some other cognitive issues. And she said when she went to the emergency room, they wouldn't even talk to her. And in fact, they had already put a DNR order on her husband's chart. And they kept saying, are you the power of attorney? Do you have the ability to make this decision? So it used to be in Pennsylvania that if you were married, they assumed that you must like the person enough to want them to be your agent under your healthcare power of attorney. Unfortunately, in Pennsylvania, they no longer assume that. So even between husband and wives, it's very important to have powers of attorneys so that if an emergency happens, your spouse can go to the emergency room, show that to the physician, then be able to talk to the doctor about what happened, what the prognosis is, what the treatment options are, and then make the decision based on that. So, and again, this is just like we talked about. Previous assumption was that you liked your spouse. And now we don't assume that anymore in Pennsylvania. And there are some complications if there are blended families. So if there is a second marriage, then there are a whole bunch of other defaults in Pennsylvania. And in this case, it wasn't a second marriage. It was still a long-standing marriage, but the emergency room physicians would not talk to the spouse until she got a power of attorney signed. So that's what they ended up coming in for, was those powers of attorneys that they decided not to do 2 years ago. So we have a couple of different types of power of attorney. So we have the healthcare power of attorney. That's going to authorize the agent to make medical decisions. They can consent to surgery. They can admit or discharge you from a hospital or nursing home. We do put the HIPAA release language right into the document. So that way, no matter where you're being treated, who's treating you, what medical facility you're at, you can make sure that you are getting the best treatment and your agent can access that information and be an advocate for you. So you may go to your primary care physician and have an emergency contact there and have signed a HIPAA release waiver there, but that's just specific to that doctor. We put it in the actual healthcare document because that way it doesn't matter who's treating you, if you're in the hospital, at your doctor's office, any of those will allow access to information to your agent. The other thing we like to put in the healthcare power of attorney and in our living will would be any organ donation requests or any burial requests or cremation requests. So we don't put it in the last will and testament. So when you die, we don't have it in that document. We have it in the documents that are effective while you're living. All of your powers of attorneys are effective while you're living, but you just can't express your wishes. We feel it's important to have it in there because your agent needs to know that you want to be an organ donor or that you want to be cremated when they're making decisions like that. So that's why we put it in both the healthcare power of attorney and in the living will. The living will is also part of the healthcare directive. So usually it's the healthcare power of attorney and the living will together. They're going to make up the advanced healthcare directive or the medical directive, however it's phrased. We actually break them into two separate documents because the healthcare power of attorney is if you cannot express your wishes, but the living will is if you cannot express your wishes and you have a terminal diagnosis. If both those things are happening at the same time, then your agent under the living will can make decisions for you. So, and I had an interesting conversation with another attorney a couple of weeks ago, and his point was he didn't know that living wills were all that effective with physicians and with doctors' offices. He just didn't think medically they were that effective. And the thing is that I think he may have a point, but that's not really why we do them. So the reason we do a living will is because if something would happen, then it's not the child who's making the decision. They're just fulfilling your wishes. So the living will, what it's really ultimately designed to do is to tell the doctor who is the person who can sign off on these decisions. In the living will, we also put things like what type of treatments would you want? So most commonly we see individuals that say, if I can't express my wishes, and expressing can be blinking, it can be squeezing a hand, verbal, writing. If they cannot express wishes at all and they have a terminal diagnosis with no realistic hope of recovery, most people would say that they're okay with pain relieving drugs being administered, even if that means an IV has to be put in, but they don't want any life prolonging procedures. So I would say that's what most people opt to do. The other thing we want to make sure to talk about is that the difference between hydration and nutrition. So some people would say, I don't want a feeding tube, but again, I don't want to be dehydrated because then I would be in pain. And so I'm okay with hydration measures being administered. We want to make sure we're specifying that. It's not to say that your agent under the living will can't deviate from that, because again, like we talked about earlier, it's not an end-all be-all document. It's a living, breathing document, if you will, and it can change based on your circumstances or your situation. But what we want to do is we want to provide guidance for those children or those family members who you have tasked with making these decisions. So it's much easier for a child to say, after understanding what mom and dad wanted and what your discussion was about this, we feel they would want no life prolonging procedures. And it's not necessarily they don't feel like it's necessarily their decision. They feel like they're following what their parents would have wanted. And so that's why we do the living will. This is just an example between the difference between artificial nutrition and hydration. So this is saying that it's directing all forms of artificial nutrition and hydration other than normal eating and drinking, all of that, to be withdrawn. And in actuality, we may say, well, no, we want the hydration if it's used for comfort measures. We do a little bit different language. So this is an example of what we put in our document. So we have one paragraph that says you're okay with pain relieving drugs being administered, even if that means an IV has to be put in, and that does include hydration. That last line under letter A does include hydration. But then under letter B, we're saying you don't want any life prolonging procedures, and that's where you're going to see the feeding tube. So this is the language we see in a lot of powers of attorneys right here, but our preference is to separate them and to do them in two separate paragraphs and say you're okay with the hydration if it's used to deliver pain relieving drugs. Thought it would be helpful so you could actually see the different language. So that's why we wanted to go ahead and put that on there. So this slide is what our document looks like as it deals with artificial nutrition and hydration. We also, in our living will, like to talk about dementia or Alzheimer's because that's not a terminal diagnosis that you could get and live for years. But what our clause says is if you get that diagnosis and the disease progresses to the point where you can no longer swallow, then at that point, you're saying you want all of your other provisions under the living will, specifically talking about no feeding tube being administered. And so we have a separate paragraph because the living will is if you're terminal and can't express your wishes. And so we have a paragraph dealing with dementia or Alzheimer's because that's not a terminal diagnosis. But it's just saying once the disease progresses to this point, then we don't want a feeding tube put in. So I wanted to give some examples of the healthcare power of attorney and the living will. Now let's move to the mental health power of attorney. So this is all still dealing with incapacity and why it's so important to consider that in your estate planning. So I always think that, people make the comment, well, it doesn't matter to me, I'm dead anyway. And for your powers of attorneys, it's so important that I'm able to express to everybody that these are so important because these are the documents that allow your agent to make decisions while you're still living. So this is protecting your interests. That's why powers of attorneys are so important. So mental health power of attorney is allowing your agent to consent to experimental treatments or drug trials. And as soon as you use those words, it tends to make people feel uncomfortable. But let me tell you why I think it's important to have this document. So I think it's important to have a mental health power of attorney because if you would ever get a diagnosis of dementia or Alzheimer's disease, and there's a drug that's labeled experimental or that's in a drug trial, but might be making some great headway in this area, and you would want your agent to be able to consent to it after they talk to your treating physician and determine that that's what's in your best interest, they cannot consent under the healthcare power of attorney. Pennsylvania does not allow the agent under the healthcare power of attorney to consent to experimental treatments. So you do a mental health power of attorney so the agent can consent to that if it's needed. The major problem with the mental health power of attorney is that it automatically expires every 2 years. So, for example, if we have clients who sign it today, 2 years from today, if they still have capacity, they have to re-sign the document. Now, if one of them loses capacity in those 2 years, then the document does remain in effect. But if at the end of the 2 years you do have capacity, then you have to re-sign it if you want to still have a mental health power of attorney in effect. Our office sends a letter and lets clients know when their 2-year expiration is coming up. And then if they want to re-execute this, we can do a new signature page and they can come in and sign that. So that's how we handle the mental health power of attorney in our office. So mistake number 5 would be a weak financial power of attorney. So this is different than mistake number 4 because mistake number 4 was all about your health care and how that works during incapacity. What I wanted to focus this one on was a weak financial power of attorney. And I say a weak financial power of attorney because you may have one And you may think, it's covering everything that you thought you needed in your financial power of attorney. But I wanted to highlight certain powers under Pennsylvania law that you specifically have to grant your agent in order for your agent to have this power. I tend to operate under the belief that if you're naming individuals who you feel comfortable naming as your agent under the financial power of attorney, that you want to give them the maximum amount of authority and power that they can have under PA law. If you don't give them some of these powers, they don't have them. And if you wanted them to be able to have them, or if they needed them for some reason, they'd actually have to petition a judge and go before the court and be reviewed and then determine whether or not they could do some of these powers. So if you're naming somebody you trust, my thought is let's give them the maximum amount of powers that they need in order to do what you would want, knowing that the financial power of attorney is not effective until you sign it and your agent acknowledges it. So you just don't have your children sign it until they need it. That's how you make sure they're not acting out of turn or before you want them to. This deserves a whole separate session, which we have done. And that's because the mental health power of attorney is kind of the MVP of powers of attorneys. If you were to have one legal document, I would actually recommend that it would be the financial power of attorney. So the first thing to know is that there are two types of financial power of attorneys. There's a durable power of attorney and there's a springing power of attorney. So a springing power of attorney just means that at some event, this document is triggered. So the ones that we see most often is incapacity. So it's springing. The triggering event is if you would be determined incapacitated. Another way we've seen it is with military deployment. It might be springing or it triggers, it becomes in effect when you're deployed. We here at our office generally, and I say generally meaning 95% of the time or more, we're recommending a durable power of attorney. Durable power of attorney means it's effective when you sign it and when your agent acknowledges it, agreeing to serve as your agent. And we do it as a durable power of attorney because otherwise in Pennsylvania, any other power of attorney, the springing one, requires two physicians to be in agreement. And a lot of times we're dealing with people who are going into a facility, a nursing home facility, and we're trying to act quickly to protect assets. So we want it to be durable so that we don't have to have two physicians determine that you're incapacitated. So how does this look when we're actually looking at it? So this is an example. I pulled this from one that a client brought into my office to review. So you're going to see it declares that this power of attorney is effective, and the agent has the authority when this individual is disabled or incapacitated. So that means that this document is not going to be effective. It's not triggered until that point. It is not a durable power of attorney. Anybody who has a power of attorney, what I would encourage you to do is to pull the document out and look through it and see, is it a durable or is it a springing? Or if you have clients who come into your office and you're not sure, is it durable or is it springing? You can look at it. It's usually in the first paragraph of the document. And you're always welcome as we go through this. You may be thinking, well, I'm not sure what I have or what I don't have. Like I said, we do the free initial consultations, bring the documents in. I'd be happy to take a look at them and I can tell you what works, what doesn't work, what powers do you need to tweak and what looks good. So the financial power of attorney authorizes typically opening and closing bank accounts, selling real estate, defending in litigation, making gifts, and creating a trust. Those are the basic language that you see in your power of attorney. But there's specific language that's needed for, in Pennsylvania, we generally call them the hot powers. Doesn't mean they're good looking powers or especially attractive powers. What it means is that these powers are considered sensitive, if you will. Sensitive in the sense that unless you're specifically talking to your client and asking them if they want these powers, then the presumption is you did not want your agent to have the authority to do these things. So the four that I want to focus on is unlimited gifting, the power to create irrevocable trust, access to digital assets, and beneficiary designations. So the first one, unlimited gifting, I'm going to use my parents again. Let's say my dad goes into a nursing home and they want to take my dad's name off the deed for the primary residence. And my dad no longer has capacity, but my mom is named as power of attorney. Unless the document specifically allows my mom to make unlimited gifts as my dad's agent, my mom would only be allowed to transfer $15,000. And their house is worth more than $15,000. So you want to make sure that you are giving your agent the ability to make unlimited gifts. Otherwise, you're going to be capped at that $15,000 every year. So even between spouses, you're capped. And so that's why we like to do the unlimited gifting. And what our language usually says is unlimited as long as it's to a spouse or to a beneficiary under the will. Second one is the power to create irrevocable trust. So if in the document it just allows your agent to create a trust, then the default in Pennsylvania is that it is a revocable trust. It is not an irrevocable trust. The only type that protects against long-term care costs is an irrevocable trust. So if we're concerned about any type of creditor at all, whether it be a divorce or whether it be nursing home costs, the only type of trust that's going to protect against it is an irrevocable trust, and the power of attorney has to allow the agent to specifically create that irrevocable trust. Thirdly, we need it to specifically allow access to digital assets. So that's something relatively new in the law. So it allows access to any online accounts and to handle anything like iTunes, Kindles, all of those type of new digital assets that we're all using so frequently in our lives. And then the fourth one I think is important is beneficiary designation. So unless the power of attorney specifically allows your agent to update beneficiary designations, then they're not allowed to. So I'm working with a financial advisor where we have somebody that has, I think it's over $1 million. I think it's like 1.2 in this bank account. It's in an investment account. And we have a beneficiary designation on that. It's in husband's name. We want it to go to wife. Wife is designated as the beneficiary, but the problem is that we need it to be in a special needs trust because wife is now suffering from dementia. And so we don't want it paid to her all outright. The company will not allow us to update that beneficiary designation from wife to trust for wife. So it doesn't matter. It's benefiting wife 100% either way we do it. The company won't accept the power of attorney because the power of attorney doesn't specifically authorize the husband to update beneficiary designation. So when you're looking at your power of attorney, you want to see, does it have unlimited gifting? Does it have the power to create an irrevocable trust? Does it mention digital assets? Does it allow your agent to update beneficiary designation? If it has those four powers, then you have an excellent financial power of attorney, and that's what you really want. If it doesn't and you're concerned, again, I'm always happy to talk to you about what you can do to change that if you want to make sure that you're being protected. This is an example. I took it from a client's power of attorney. So you're going to see in here that it allows 8 and 9, it allows your agent to engage insurance transactions and retirement plans, but nowhere does it say beneficiary designation. So because it doesn't allow the agent to update beneficiary designations, and that means that this person as agent would not be allowed to update any beneficiary designations. You're going to see down here, it says to create a trust for my benefit. So because it doesn't say the word irrevocable, then that means that the agent cannot create an irrevocable trust. So therefore, that means it's not protected against creditors, the biggest being a nursing home. So you wouldn't be able to create an irrevocable trust with this. And then you're going to see here that it doesn't allow gifting. So, it's talking about transfers, all of that, but nowhere in any of this does it allow for an unlimited gift. You don't see the words unlimited in there. It just allows you to make additions to an existing trust, but nowhere does it say unlimited gifts as long as it's to a spouse or to a beneficiary under the will. So all that to say that someone took the time, the expense, they paid for this power of attorney, and in reality, this power of attorney will not allow them to do anything. There's absolutely no power in here that the agent can do that's helpful to protect assets. So engaging in real property transactions, again, it doesn't say anything about, can they gift it? Can they sell it? All of that. So you may have a power of attorney that really is not worth much at all. It's not going to allow the agent to do much at all. So you want to make sure that you're looking at the document and having good language in there. So what's an example of good language? So some from our power of attorney dealing with trusts. So this allows the creation, funding, amending, modifying, revoking, or terminating. You're going to see a revocable or irrevocable trust. That's the language that we need to have in there. For the gifting language, this is what we use. So to make unlimited gifts without regard to the federal gift annual exclusion limits, as long as it's to a spouse, to an issue, which is a child, or a beneficiary named in the last will and testament. So instead of just saying to make gifts, we actually spell it out there. And it even includes language in here about how it would allow you to qualify for medical assistance. Beneficiary designation language, this is what we use in ours to designate and change beneficiaries of such plans or arrangements, provided that the designations and changes are consistent with my known or probable wishes. So again, we don't want the agent to just willy-nilly be updating beneficiary designations, but there could be a very real need for updating beneficiary designations. Digital asset language, so this is how we started off. They can access, modify, transfer, delete the digital assets. And the last thing I think I have about the financial power of attorneys is that there was a law change that happened in January 2015. This law was signed in July of 2014, but it became effective January 1st, 2015. So if you have a power of attorney and you're looking at it and it's dated prior to January 1st, 2015, it's worth having an attorney take a look at it because you want to make sure that it's staying up and compliant with all the new rules and regulations. And this is important. This just talks about the court case. It was actually two teachers, husband and wife, married to each other. And wife was in an accident, was in a coma. Husband used the power of attorney and made some elections about some survivorship benefits on her retirement account. Wife woke up. They decided they didn't like each other anymore. They got divorced. And then wife was mad that husband could use the power of attorney to make certain elections on her retirement account while she was incapacitated. So then banks started refusing to accept powers of attorneys. So the law changed in January 1st, 2015, which just says that if it's executed with the proper requirements, which is a notary and two witnesses, the bank has to accept that power of attorney. Now, trust and capacity, we talk a lot about trust and asset protection, but it's also worth noting that a trust can help with capacity because the POA law, power of attorney law, changes all the time. So another benefit of using a trust is that you set up the trust, you transfer assets into it, and it doesn't matter if you would become incapacitated because the trustees, the successor trustees, do have an immediate ability to start using those assets or managing those assets. So a trust is also helpful during incapacity as well. Why do you need a power of attorney? And this is specific to a financial power of attorney. We do this in the sense of long-term care planning. So the average cost of a nursing home in Pennsylvania is $11,099 per month. If you multiply that by 3 months is about how long it takes to get a guardianship if you don't have a power of attorney or if your power of attorney doesn't have the language you need in it. And that's about $33,000 that you're going to have spent when, if you had a good power of attorney, you would have been able to save those funds. Mistake number 6 is dealing with long-term care. So our office does a lot of long-term care planning. We like to do this. We like to help people protect all that they've worked really hard for. So this is just talking about how people are living longer and they're living in assisted living and nursing facilities. And so how do we protect against those costs? And especially when we're talking about a husband and wife, because if, let's say, my dad goes into a nursing home, my mom is allowed to keep her retirement. She's allowed to keep one vehicle, the one of highest value is typically what we recommend. My mom would be allowed to keep the primary residence, although when she passed away, there'd be a lien if my dad was in a nursing home. And then she's allowed to keep about $130,000. The rest of my parents' assets could go to pay for my dad's long-term care. So it's so important for husband and wives to consider this because if one of them needs long-term care, it could make the surviving spouse financially compromised for years to come. So how do we do that? There are two ways. We partner with financial advisors who can come up with insurances or investment products that provide long-term care, either insurance or maybe a rider benefit on a certain policy. So sometimes it's that way. The benefit of that is that there's no look back period for it. The way we have legal means to protect is that we can use irrevocable trusts to do that. And there's a 5-year look back period for these irrevocable trusts. So you have to make sure that you're doing it in plenty of time. But if you set up the trust and you transfer assets into it, then those assets would be protected against both spouses' long-term care costs. So that means that when we're looking at this slide here, the spouse is still keeping their own retirement, still keeping a vehicle of highest value. The house they're still keeping, and they may want to transfer it into the trust to avoid that Medicaid recovery lien, and they're allowed to keep $130,000, plus they're allowed to keep whatever's in the trust, as long as you made it through the 5-year period. So this is talking about asset protection and why we think that's so important. It's really all about making sure that you're evaluating, you've worked hard for this wealth, and being good stewards. And so, how do we make sure that the spouse is protected to the maximum amount? And so, that's what an asset protection plan is. So, it's not about hiding assets because the assets, you're allowed to do it under law and the assets are fully disclosed. It's just that Pennsylvania law does allow you to protect assets using these trusts as long as the assets are owned by the trust for 5 years. So, we're just using the existing law and maximizing that benefit. What it looks like, and this is John and Jane Doe, but I'll actually probably use my parents because I think it's easier when you can think of a situation. So I'm one of 4 girls. I have 2 older sisters and 1 younger, so there are 4 of us, mom and dad. So what they may do is they may do something like this, set up 2 different trusts if they want, and they might put their house in one and then maybe some investment accounts in the other trust. Mom and dad would still be the trustee. They're still making all investment decisions, deciding about buying and selling, still in full and complete control over these assets. The only thing they cannot do with these assets is they cannot reach in and pull them back out because they're irrevocable trusts. So what we do is we say the power of distribution that normally the trustee has, we're going to take that one power and we're going to give it to what we call the trust protector. Let's say the trust protector, my parents feel comfortable, they would name my sisters and I. So that it would be all 4 of my sisters, or all 3 of them, total of 4 of us. So mom and dad would still be the trustee. They're still doing everything that a trustee normally does. But if they want to pull out $100,000 out of the trust, what they would do is they would come to my sisters and I and have us sign something agreeing to that. And if we agree to it, then they can pull out that $100,000 and the rest of the assets are protected against nursing home costs. So it's a great way in Pennsylvania to protect assets, but still allow access to the asset. Now, let's say that I'm being contrary and I'm saying no. When mom and dad say they want 100,000, I'm saying nope, I'm not going to give it to you. My parents can actually fire me from that position, and they can use my other 3 sisters if they want to. Or if they need to add somebody else on, they can add and remove beneficiaries as well as add and remove the trust protector. And the trust protector is the one who can reach in and pull out assets. So it is still a very flexible document, and it still allows maximum protection, but most control. Again, you just need those additional signatures when you're pulling something out of the trust. If my parents would put their house in the trust, and let's say they decide to sell it, because they are the trustees, they have full ability to sell those assets. They don't need my sister and I's involvement at all. So they could sell their house, they can buy a new house as the trustee. None of that requires our involvement. If they sell their house and they're downsizing and they have 100,000, and let's say they want to pull that out because they want to buy a car and they want to go on a nice vacation, then they might say, okay, we're going to buy the new house in the trust. They still don't need us. And then the rest of the money they're going to invest with the financial advisor. And if they wanted to pull out that 100,000, they would just have my sisters and I pull that out for them and gift it to them. It's not going to be in our income taxes. We don't have to pay income on it because it's considered a gift to us. So it's a great way that you can allow clients and family members to have full and complete access to the assets while still allowing the protection. And we're really trying to make sure that both financial advisors and our clients know that this is an option, because it really does provide a lot of flexibility. If we have husband and wife and one spouse only needs assisted living level, so they're going to have to private pay, but the other spouse is in a skilled level at a nursing home and Medicaid can pay for that, then the trust is really helpful because it can be used to pay for the assisted living spouse's care while the other spouse can be on Medicaid. So it offers some great flexibility and protection for husbands and wives. Then we can also say upon death, it can go in trust to the children. And just talking to my parents and helping them with their estate plan, I know that that's very important to them. So some of it is, they don't have, their one son-in-law isn't their favorite. They love him, but he's not their favorite. So if something would happen to my sister, they would want it to go in trust and it wouldn't go to that son-in-law. In my case, I'm not married. So, they don't know. Maybe I'll end up with a dud as well. So, they may want it to go in trust for me as well to protect against that. And so it's nice to be able to do some legacy planning for future generations. And it all starts with long-term care planning and nursing home planning. And we're able to do that as long as you keep in mind the 5-year look back period. As we do, like I said, monthly virtual seminars. And last week we did have our first in-person one. So we'll keep everybody updated. We did that in conjunction with Hurley Auctions to talk about that process. And we're going to be posting that on our YouTube channel. So you can check us out if you go to YouTube. We post all of our seminars on there. You can always go back and watch them. Our next monthly seminar is August 18th, 2021, and it's all centered around those couples or individuals who have underage children. So we're doing it in they're going back to school. So we're going to focus it on families that have younger children. You can register for that by emailing Amy at our office at her email address there. You can call us. You can also register on our website as well. So those are the 3 ways you can do it. After today's seminar, we will be emailing you a survey link. Please be honest. Tell me what you liked, what you didn't like, what you would like me to cover more in depth, and I'd be happy to do that.